Yeah, topic number 9 talks about aiding and abetting. Till now, we were basically, focusing on actus reus and mens rea of the person who was committing the offense himself. Like we were basically focusing on the person, accused person. And even in the actus reus, what we saw, act of the accused, not of somebody who was, standing next to him, or like we were not at all bothered about where there were, more than one person. Now we are talking about extension of criminal liability. What do you mean by extension of criminal liability? Is that when the criminal liability is extended to the person more than one. Okay, more than one person it is extending, and up to what extent it is going. There are different chapter like aiding and abetting, counseling, and other parts are also there. So we will see who are the different party to the offense in this lecture, and how that person is basically becoming criminally liable. We are bothered only about if that person could be participant, right? As a participant, he could be present in that particular situation. But we need to only consider about whether that person is criminally liable or not, and if yes, to what extent they are criminally liable, and under what section they are criminally liable. So, the meaning of aiding and abetting is assisting, helping, physically supporting, and inciting or encouraging other person to commit the offense. So, about aiding, it is assisting, helping, physically supporting. About abetting means you are inciting or encouraging the other person. You're cheering the other person, saying that okay, let's do it, like you have to hit that particular person, otherwise what kind of a man are you, or something. Okay, it is inciting, it is coming under abetting. Okay, aiding is a different thing, abetting is a different thing. So do we understand the meaning of aiding and abetting?
Yes.
Yeah. So, for example, closing the door behind, providing a gun, driving vehicle to the crime scene, these could be considered as aiding. And abetting could be provoking a person, cheering, behind. So you can write here, these are aiding, and for abetting also you can, write that, okay, cheering, or here itself you can make the distinction. Now, the important section here is section 21, subclause 1, and section 21, subclause 2. So both of these subsections we have to understand. So basically section 21 of the criminal code is what we are bothered about. Now, how will you use this in the exam also? I'll tell you now itself. Whenever more than one person is involved in your exam question, fact pattern, then definitely you talk about section 21. Whether you mention whatever here is underlined, you have to make summary of these. Okay, don't write as it is the entire section. It will take up time also, space also in your answer sheet. So try to have a very summary, and at least know that okay, this is section 21 clause 1 talks about who are the parties, who are the parties to an offense. So there are three parties to an offense. One person that is actually committing it. Another person, we also call it as principal offender. Okay, we can call him as him or her. I'm just being general neutral when I say him. So when we call it here this one principal offender, okay, the person who actually commits it is the principal offender. Then does or omits to do anything for the purpose of aiding any person to commit it. So they are aiding, they are helping, assisting physically, doing something or not doing something. So in order to do or omitting to do something, that is for the purpose of aiding a person. For example, I'm not calling the police. I'm omitting to call the police whereas I'm supposed to in that situation. Then I'm aiding that particular person, right? I am closing the door behind. I am doing something that is aiding that particular person. This is relatively a easier topic, but you do feel free to stop me in case if you need additional explanation. Okay. So third point is abets any person committing it. So first person is principal offender. Second one is who is aiding that particular person. And third is abetting, who is encouraging, who is inciting or provoking that particular person to commit that offense. So all these three people are having something in common. What do they have in common? That is under common intention we have under 21(2). Okay, under 21(2), we can clearly understand that there is a condition that connects these three people. It should not be that the person who is committing it is having one intention, and the person who is aiding has another intention. Person who abetted was for some other intention. We have five major syllabus cases, which will give us instances of different instances. And in that situation, how will you find one person liable, and one person in such situation not liable, based on the findings of the court? So we will understand through those major five syllabus case laws. But as per the statute, let us just understand what is the common intention that they are seeking. Where two or more persons form an intention in common to carry out an unlawful purpose and to assist each other therein. So the point is they have to assist each other therein, and any one of them is carrying out the common purpose commits an offense. Each of them who knew or ought to have known the commission of the offense would be a probable consequence of carrying out common purpose, is a party to that offense. So they are telling about, okay, the person whoever commits it, na, so if they are having other people who are aiding and abetting, if they have common intention, they have to have a common intention of committing that offense which he committed. For example, now four friends go plan to rob a bank. Okay, it is the very easy example, and we'll also see case law around it. Very easy example. You can imagine this situation. Four friends are there. They're very notorious, and they plan with each other that okay, let's rob a bank, and all four of them have a common intention about robbing a bank. Now, if they go and rob a bank, then all four of them are party to that offense because they had a common intention of robbing the bank. That is the offense they are charged with ultimately. They did not do anything else. Okay. So this is the first scenario where only they robbed the bank, and that is the intention that they had. It is matching with the end result. Okay. With the end consequence. So they knew what was going to happen, even though one person does it. For example, one person planned it, one person abetted it, and another person was assisting, like carrying the bag, and like waiting at the door, driving and all, getaway car. So all these things, so they are doing different part. Only one person went inside and actually robbed the bank, doing the performance. So what is that? The common purpose commits an offense. So carrying out of the common purpose, if one of them is carrying out the common purpose, each of them who knew or ought to have known the commission of the offense would be probable consequence of carrying out common purpose, is a party to that offense. So like yesterday, how I wrote the answers, connecting the Bare Act material to the fact, same thing you have to do here also. Whatever they have given in your question, you have to connect where two or more person. In the instant case, Malcolm and Tom have the common intention of doing this particular unlawful purpose. It's not like, okay, let's take a ride of this particular bike. Not like that. Some unlawful purpose. It has to be with respect to unlawful purpose only we are talking about. Okay. So they should have a common purpose. Common purpose of common unlawful purpose. Sometimes what happens, even in the exam, they'll give you some situation like both two friends plan to go to a party. Okay, plan to go to a party, and after they reach the party, one of the friend, okay, Tom and Harry, there are two people. Actually, Tom had drugs with him, and he starts distributing it over there. Harry did not know that Tom had drugs with him, and he's going to the party only to sell drugs and make money. Now Harry is innocent, no? What do you think? Do you think Harry had the common intention of selling the drugs, or did he have only the common intention of going to the party? What was his intention?
Only for the party.
Yeah. So his common intention with the Tom was not of some unlawful purpose. Okay, so I'm just trying to break down this section for you, and how to rule out some people in your exam question. Some characters you have to rule out that, okay, acha, this person has not done anything, only this person is liable. Okay, just a second, let me. So when two people are going for the party and they are planning on, okay, Tom and Harry are there, and only their plan was to go for party earlier. And after we reach to the party, those two people reach to the party. What happens that Tom starts selling drugs, and Harry had no idea that Tom had drugs with him, and he had intention of selling those drugs. So now the common intention of those two are only with respect to a lawful purpose, that is of going to a party. Unlawful purpose, they did not have any common intention with respect to what ultimately offense was committed. The offense committed by Tom had nothing to do with Harry, because they did not have common intention. So in your exam question, they will give some multiple characters, and they'll give you multiple scenario, like okay, they had this much plan and they are doing like this, they're doing like that. So at the end of this class also, we will look at the question that I had shared. So we will see ki, what exactly uh, how exactly to apply what we have learned in today's class, and to what extent this criminal liability will be extended. So what is mens rea here? in in common intention, or when you're calling it as, okay, when more than one person is there, no, so that time when you are applying section 21 of the criminal code, that is parties to an offense. Okay, when there are more than one people, you will apply to section 21 in your answer, and you will say that as per section 21 of the criminal code, it suggests that um, person who commits the offense, along with the person who is aiding that particular person who is committing the offense, and the person who is abetting the person who is committing the offense. So there are three people who are parties to an offense, and they should have common intention. So you are applying that section and you are talking about it. But what is the mens rea here? What kind of mens rea here is applicable? So here in R versus Briscoe, one of your syllabus case, which talks about mens rea part, the code drew a distinction between the words intent and knowledge. They drew a difference between the distinction between the words intent and knowledge, and they said that as it was mentioned in section 21. Section 21 talks about intent and knowledge. So here, what is the difference between intent and knowledge? According to this case, court said that Crown has the burden of proving that the accused intended to assist the principal in the commission of the offense. That means the accused person had the intention. He had the intention. He had plans to assist the principal. Principal here is the person who is committing the offense. Okay, principal offender, the person who is actually committing the offense. So the person who does that actus reus required for the offense section. Now, other people are doing other parts. Okay. Now, this accused person has intended to assist the principal in commission of the offense. It is not required that the accused desired that the offense be committed. Now, what is the key difference here? He intended to assist. He did not desired that the offense be committed. Now, for a number of reasons, people will be assisting another person just because he's the spouse, he's the love of their life, or friend, best friend, because they are in a gang, right? So a number of reasons are there. Even though he did not have the desire, He did not have the ultimate desire of that particular offense being committed, but he intended that this offense be committed. I'll give you an example. Now, the intention that Tom and Harry only, let us change the scenario slightly. Now, Tom and Harry are best friends. Okay. Now, Tom says that I'm in such a financial situation. I'm in a tricky situation. Let's sell some drugs. Please help me. Come with me to the party. Let's sell drugs. So he has told the story to Harry, and knowingly, Harry goes to party along with Tom, and they both, Tom goes with him. He does not sell the drugs, but he goes with him. He drives him to the party, and he also carries the bag when Tom is talking to other customers. I don't know how this drug deal and all goes. So he's basically assisting. You get the gist, right? So he's basically assisting. He's carrying the bags and all, and looking out for if somebody is snooping and all. So he's assisting him. So he had only intention to assist him, to help him, okay, in commission of the offense. But ultimate, like, okay, now drugs should be sold, that is not his intention. His intention is to, I mean, that desire is not there. It did not originate in Harry's mind before this guy asked for help. It did not originate in the mind of the accused. Are we clear about intent? Any doubts?
No,
Now,
this is good.
okay. So now about knowledge. About knowledge, here, accused must be aware and know that the principal intends to commit the criminal offense. It is sufficient that the person knows that the principal intends to commit the crime, although he or she not know precisely how it will be committed. For example, here, here same situation we can apply knowledge also, because accused person here is Harry. Okay, Harry is the accused person, and Tom is the person who has actually committed this. So he is the principal. So it's all the, original plan of Tom, and Tom is the person who is actually selling that also. But our accused person Harry is only assisting that particular circumstance, right? The act. So he's just assisting Tom. Now what happens is that he knows, because Tom has told him that, see, this is the thing, whatever may be the reason, he has told him that we are going to sell the drugs, and he is assisting knowingly. But he does not know how much drug is to be given to what person, and how the drug deal actually goes, whether they are paying in cash, not paying in cash, whether they are slipping into their pockets, or whether they are supposed to drop it in a particular area or not, like how it is going to happen, how precisely it is being committed, he does not know. Just knowing that he is going to sell the drugs, that unlawful purpose is there. No, unlawful purpose here is the drugs, selling the drugs. So that much is sufficient to prove. Okay. So knowledge also, when you are a crown counsel and when you have to prove somebody aided particular commission of offense, you have to prove that they had every intention of assisting that particular person, aiding that particular person, even though they did not know. Because lot of times in your question they will give that they know what the friend is going to do, but they did not know how to how they are supposed to do it. So that is the reason why they are claiming defense and all. They'll start making stories. I knew that it was going to happen, but I didn't know how it was going to happen. So that is why I'm not a party to it. But I was there. So such stupid definition, I mean defense and all, they can't take. Okay, because as per this case, they have clearly mentioned intent and knowledge with respect to this section 21 should be taken from this particular, uh, you know, definition. What our distinction has brought around by the court. Now we will go to syllabus cases. There are 5 syllabus cases, very important, and these will be, coming up in understanding when you're answering your paper. You will be basically using these syllabus cases. And yesterday, I think while we were answering, Shreya suggested one case law. That case law is also a syllabus case. I went and checked, it is there, and we are going to learn that in in the counseling or other chapter. Okay, so we will be discussing about that case law also. So don't worry. Whatever syllabus case laws are there, we are going to discuss that. Just because in under the attempt part, we are going to discuss that case law. Just because we were discussing this fact pattern much ahead than the chapter had happened, so we could not basically pinpoint that this is the case law we had to apply, but it is there in our syllabus and we are going to cover it. Now, these are the syllabus cases with respect to aiding and abetting. So, R versus Dunlop and Sylvester, what happened here was there was this sexual assault going on in a club. Sexual assault is the offense that is going on in a club, and there were some bystanders. Okay, one second. There were some bystanders. Now, the main question in this case was whether bystanders should be also made a party to that particular offense or not. So here, the court held that mere presence and acquiescence. Passive acquiescence means they're just present there. They're bystanders, innocent bystanders. We have this concept in our Indian Penal Code also. You might remember. So mere presence, not participation in the offense. Okay, mere presence and passive acquiescence does not amount to aiding or abetting. Both it is not coming. Aiding also it is not coming. Abetting also it's not coming. Only it is mere presence and passive acquiescence. Now, to what extent passive acquiescence and what extent mere presence and all, that as per case to case basis we will see, but only you take this point from this particular case that yes, there was a sexual assault or offense going on and in a club, and there were some bystanders, and the main question here was who should be, who should be, whether this bystander should be made party to that particular offense or not, whether they should be charged or not. So, can anybody read this paragraph for me?
Being present alone is not adequate to establish culpability. Presence at commission of an offense can be evidence of aiding and abetting if accompanied by other factors such as prior knowledge of the principal offender's intention to commit the offense or attendance for the purpose of encouragement. Quote, no evidence of any positive act or omission to facilitate the unlawful purpose. Mere presence and passive acquiescence does not amount to aiding or abetting.
Yeah. So that is the facts of the case. And so what you have to do in the supplementary notes, you will not find the facts. Okay. Because if you go on mentioning the facts and a little bit like too much. So what you have to do, you have to make the point here when once you print it out or you are making your own notes. I'm not sure, how you would like to take this forward, because after 2 weeks of our class, I think you will get an idea about, okay, how this is going to help you, whether if you have straight printout as it is, or if you want to change it into a slightly little different, you want to change. And I will be sharing word copy of these files very soon, immediately after the class. Around like 1 hour I'll take, and I'll just convert everything into word and share also, because if you want to slightly, and I'll be telling the facts of the case, like very key facts, like here what happened in one sentence: sexual assault in a club, there were some bystanders. That's it. So that you have to write here. Okay. Now, with respect to the key ratio that happened here is this one. Mere presence and passive acquiescence does not amount to aiding or abetting. Any question? Can we go to the next case? Okay. Another just 2 lines here, but what happened in this case is R versus Logan. Robbing bank was the plan. Okay, so here there were more than one person involved in this case, Logan and his friends. They had planned to rob the bank. Okay, they had planned to rob the bank, but Logan had gun, and others did not know that Logan had the gun, and they did not know that he intended to harm somebody with that particular gun. So here, with respect to what point we learned here, something about knowledge, no? We learned something about knowledge. Intent, yes, of course, they had the common intention of what? They had the common intention of unlawful purpose of robbing the bank. So in this case, what happened? He had the gun and he went inside along with his friends, and other people only thought that they were only going to rob the bank. This guy, Logan, he takes out the gun and he threatens the manager, and manager, of course, he will, he there actually resisted the robbery, and then Logan actually shoots the manager. Okay, and he dies. Now, what happens whether manslaughter or murder or any section that is going to be charged on Logan is going to be charged on his friends also or not, who went only with the intention of robbing. So what do you think, whether there is a common intention of hurting the manager or shooting somebody, basically shooting somebody?
If he has knowledge the hello.
Yeah, do you think
If the
yes or
other
no?
person has knowledge about the gun, then it can lead to common intention. And if he doesn't have the knowledge about the gun, then there will be no common intention.
Exactly, you're right. You're right to the point. So if they have the knowledge, then there is common intention about shooting, because mere knowledge is sufficient. Because having the gun, there is probable cause. They can foresee, right? They can foresee that yes, the gun is there. It is robbery happening. That means there will be some casualty. Even if some casualty is going to happen, I will be liable also. So they are agreeing and they're seeing the risk and they're still going ahead and doing. All those things will come. But intention is there and also knowledge is there. But here, knowledge was not there of Logan's friends. That's why they said that here, when subjective mens rea is required to convict principal of attempted murder. So in this case, the manager did not die. Okay, Logan's case, manager did not die, but shooting was there. That's why attempted murder charge was, applied. So convict in order to convict the principal of attempted murder, subjective mens rea is required. Then that same standard must be applied to convict party of the offense. That means other people also should have the same subjective mens rea that is required by this principal offender. That means Logan is the principal offender who actually had the gun and who actually shot the victim. Now, Logan is charged with being a principal offender under Section 21. He is the principal offender, person who is actually committing it. Section 21(1)(a) actually commits it. Okay, he is the principal offender. Now, other people who are the party, in order to party to that particular offense of attempted murder, okay, in order to be a party of attempted murder, they also should have the same standard, that is subjective mens rea. Subjective mens rea is intention of the accused. That means they should also have the knowledge, they should also have the intention to kill, or committing the offense of attempted murder. Okay, so they failed, they were of course the person did not die, so it is attempted murder. Yes, Priya.
So basically, uh, so basically, the first example that you gave, where a friend was carrying, like he said that he wants to sell drugs in the party, and the second guy said, no, I don't want to, right? Basically,
Mm-hmm.
and but he still goes to the party together,
Mm-hmm.
and the first guy sells the drugs. So by this case law, he won't be convicted.
Okay, if he agrees, okay, if he straight away says no, if he straight away says no to the selling of drugs, but if, okay, yeah, but he has to take some steps also. We will see that in the next case. We will see that if the party to that particular offense, he is present in that situation, and that's a very good question. It will come up in the next case where they
Oh,
are planning together, or if they have the knowledge. but they should still take certain steps. This is what I like about criminal law, Canadian criminal law, is that they go to such, minute extent also, and they say that, okay, if you don't want to do, fine, but you should not go scot free because you earlier you planned, no. So now you take these steps in order to make yourself, free of this charge. So what they should do, we will see in the next class, next case itself.
Okay.
Okay, yeah. So that is about R versus Logan. R versus Logan, just the fact is this much: robbing the bank was the plan. Logan had a gun. Others did not know that Logan had the gun, and they did not know that his intention was also additional to robbery. It was to hurt somebody. In case somebody is resisting, he would have hurt somebody. That intention was not known by other people. Okay, that's why they, whenever the other parties are to be made party to that particular offense, then same standard must be taken in order to convict the other parties to that particular offense. That is the subjective mens rea of that particular person, other parties. Next case is also interesting. Here, what happened? R versus JF. Okay. So R versus JF, there were two sisters. They were planning to kill their mother. Okay, so all these case laws are very interesting. Like it's of some offense, right? Like story it is. So very easy to remember. So R versus JF, what happened? There were two sisters planning to kill their own mother, and they were the brother also came. Okay, they were discussing. They were conspiring. Basically, the word is conspiring, and brother comes, and brother also starts saying, you should do this in order to avoid the chance of her getting saved from drowning. You should take this much precaution. You should, poison may itna proportion. You should add alcohol or something. So he was blabbering. He was basically giving some kind of ideas. Okay, some kind of ideas and backup plans and all. But these two sisters, they do not take those pointers into consideration. Whatever the brother said, they did not follow it. They did not involve him in their actual plan. Now, what happened? The court said that the court here said that although a party liable to conspiring involves aiding or abetting the formation of a new agreement, it also includes aiding or abetting a new member to join a pre-existing agreement. So there are two situations where earlier there were only two sisters who were planning to kill the mother, correct? So later brother wants to join, then there has to be two things. One of two things has to happen. Either he has to join the pre-existing agreement, or they have to form a new agreement. Okay, there has to be a formation of a new agreement. In this case, none of this happened. He was saying something independently. These people were there, of course, but they did not take that into consideration. They did not form a new agreement. Also, they did not form they did not make him join, make a party in pre-existing arrangement also. And in this case at hand, there was no evidence that J aided or abetted. J is the brother, aided or abetted the original initial formation of the agreement between the sisters to kill, or aided or encouraged new member to join existing conspiracy. So they said that as a new member, he did not join as a new member by encouraging them, and they did not form a new arrangement, or he first of all, they did not form a new arrangement, and he did not have the he did not join to the previous arrangement also, pre-existing arrangement also. So this particular evidence was not there that he could be a party. The crown was basically failed to prove. ये सारे चीजें ना, like on all these cases could be either way, but ultimately what we are learning is from the verdict of the judgment, right? Like judgment of these cases. So Crown must have failed to prove that even though such statements came into picture, that brother also was involved, and he basically conspired along with the sisters. He was also giving some points and all, but he was not held liable, criminally liable, as a party to that particular offense. Okay, although party liability to conspiring involves aiding or abetting the formation of a new agreement, it also includes the aiding or abetting the new member to join pre-existing agreement. That says that already एक पहले से formation होना चाहिए, या फिर it also includes pre-existing format में कोई new आना चाहता है, somebody new is joining, that also is included. That is what the court held. But in this case, there was no evidence that either there was no proof that he joined the previous arrangement of the sisters and they all three followed the same thing. ऐसा नहीं था. And also there was nothing to say that show that they formed a new agreement. Is it clear?
Yes.
Yeah. So you can use this case and rule out some parties from the offense, even though they acted in a manner that this person could be a party, but actually if there was no actual joining of the previous arrangement, or if there was no new arrangement, then you can say that that particular person is not a party to that particular offense. And ऐसा कोई comment मत करना कि that person is not liable to anything, only that particular offense. So be specific, that offense, he is not a party to that particular offense. Okay. Next, here is where we are going to learn about what you had earlier asked. Ki what if they know what is going to happen, but they either change their mind or they are not supporting the plan? How to go about it? So R versus Gautier, very sorry, just a minute. This is very I wouldn't say interesting case. It's a very traumatizing fact. Okay, so you might remember in North India there was one case also, like 11 family members committed suicide, right? And ultimately, like what I have seen one documentary also where it was shown that ultimately, like it was all um, plan of one particular person, and other people were kind of under the authority, whatever maybe the reason, their belief and all those things. I just saw the series and understood. So now here in this Gautier case, R versus Gautier case, what happened was husband and wife, okay, husband and wife plans to commit suicide and kill their children also. Basically first kill their children and commit suicide. So their plan was to do that involves poison. Okay, they first wanted to take poison. Everybody wanted to take poison and slit the throats of the kid and slit the wrist also. Okay, it is that's why I said like quite traumatizing fact, because so the fact includes husband and wife are there and children are there. Now it includes poison and slitting throat and wrists. Okay, this is the key fact. Now they had both planned, husband and wife both planned to kill the kids and commit suicide. What happens here is that wife changes her plan after killing the kids, after husband also slits his wrist and throats. She then decides to abandon the plan, and she says she calls the ambulance and she calls 911 police or something. And ultimately what happened, she was saved and other everybody died. Okay, this is the fact. Now she actually took the defense. She was obviously she will be charged with the murder and attempt to suicide also, right? So she will be charged with the murder of children and husband. And obviously husband is not there to say something or to prove that he also had the plan or not had the plan, and we can't punish him also, right? And of course children are innocent and they were minors also, I think, in this case. So basically what we are concerned about this case is that abandonment. So she took the defense of abandonment, that I changed my plan, I withdrew from the plan. I had, yes, of course, I had the common intention of doing this along with my husband, but it was his plan. I just went along with it and I abandoned the plan at the end. She called the police, no, at the end, but she only saved. No, nobody else was saved. So at what stage abandonment is allowed, at what stage the defense of abandonment is allowed, and how to actually abandon a particular common intention and what they should do. So court actually held that in this case, elements of defense of abandonment were discussed in this case, and those were these 4 elements. Can anybody read these four elements for me?
Yeah. There was an intention to abandon, withdraw from the unlawful purpose. Timely communication of this abandonment from the person in question to those who wish to continue. Communication served unequivocal notice upon those who wish to continue. Accused took into proportional accused took in a proportional manner reasonable steps to neutralize or cancel the effects of his participation or to prevent the commission of the offense.
Thank you. So here there are 4 elements. So what she should have done is that first one, there was an intention to abandon or withdraw from unlawful purpose. पहले तो intention होना चाहिए that yes, she was actually planning, she was intending to withdraw or withdraw from that particular unlawful purpose. Unlawful purpose here being the murder, and after the fact she did na. So but that intention has to be there before only. That is what the second point. Timely communication. Timely communication of this abandonment from the person in question to those who wish to continue. For example, here husband. When husband was still alive and before committing the offense of killing the children or mixing the poison, anything. Timely communication means before the fact. Before the fact. Okay. Now, third one is communication served unequivocal notice upon those who wish to continue. But that means there has to be a proper notice. Proper notice should be there means if you are communicating with that person that you don't want to do this, go ahead with this, and they should also try to say that, try to communicate that this is not right thing. Chalo, like bachon ko nahi marte hain, like should let us not commit suicide, let us call for help. We need some counseling or something. Something she should have done some kind of communication where she finally decided to do this was after the way after the fact, right? And आपके अगर facts में दिया है कि even if they are dropping from the planet, they are just getting underground and not going and participating in all those things, still they will be made a party to that particular offense. इसीलिए all these 4 points are really important. Whenever you feel in the fact it is mentioned that one person in the fact, one character who was there in the earlier plan, but later on they change their mind and they do not come only. But they did not do all these things. They had the intention, but they did not make the timely communication that abandonment with the those person who wish to continue. Okay. Earlier, whoever was in the gang, they did not say. And communication served an unequivocal notice upon who wish to continue. Ek notice nahi diya, suddenly they changed the plan and they did not go. But other people continued to do so or whatever. Now, accused took proportionate manner reasonable steps to neutralize or cancel the effects of his participation or to prevent the commission of the offense. Now, this point is very, very, interesting. This is where most of the time, ये दो points somewhat they can say that yeah, हमने तो बोला था उन्होंने नहीं सुना, right? But this is where they have to prove. Accused has to prove that they took proportional manner reasonable steps. In a proportional manner means whatever their role was. Of course, like if their role was to get the car or something, and they were not the person who was planning the entire thing, or they were not such um, for example, head of the like leader of that particular group or something, they were a new member or something. Obviously we cannot expect them to shout and tell other people, take charge of the thing and change everybody's mind, right? So that is why proportional manner reasonable steps. Proportional manner means in their capacity how much they can do, that much they should do, and that much they should prove in the court also. Whenever they are also charged with while taking the defense, they should, while taking the defense of abandonment, if they're not taking the defense of abandonment, let's forget about this. Okay, obviously they are only not taking this abandonment defense means what. But in case if they're asking ki okay, so and so party who change their mind and they come to you. They come to you for asking the opinion how they can be saved, or like is there any provision under the law or any case law that supports him, and how best can you defend as a defense lawyer. So that time you can say, as per R versus Gautier, my client situation fits the description that was mentioned in the elements of defense of abandonment, as discussed in the R versus Gautier. And the courts gave these 4 elements, and in my case, each element you have to discuss whether he did this one, this one, this one, this one, all 4. And fourth one, you have to say that whatever in his capacity, he took reasonable steps to neutralize. Here in this case, Gautier, she should have done okay while mixing the poison. When husband went and got the poison from the store, when she was mixing it, she should have not mixed it. She should have replaced the actual poison with some other substance or something that she is doing, even if she doesn't have the authority to speak up to the husband. At least she should have done something indirectly also, directly or indirectly, to take steps to neutralize or cancel the effects of his participation, or to prevent the commission of the offense. She should have called the police, called for some help before the commission of the crime. So here finally the court said, in the case at hand, communication was not reasonable and sufficient. She told it afterwards, and no effort was made to neutralize the commission. She could have called the cops, hidden the drugs, etc. She could have done so many things. She didn't do. So yeah. So this case, all okay. That's all about this case. Any doubt? Arvis has got here. Good. So we should understand all these cases in a story manner. Then if you make a note of the facts in a different colored pen or something, or pencil here, so that it'll on the day of the exam, okay, this kind of fact I know somewhere, so you can refer to your key points, and okay, that case you will. Obviously I will not remember gotcha case, husband, wife, children, that murder and all those things, right? Poison, abandonment, all those things I will not remember. But I know which chapter it is. Aiding and abetting. I'll come to that chapter and I will see my key points, my keynotes, and I will say that, okay, this is the case I have to write. So like that, you will make one, brain map, or hints for yourself. For yourself, you have to make those hints that I can't do. Now, with respect to R versus Coven, what happened here was there was a robbery happening in subway. The robbery happened in a subway. Then the police had got a description of the person who did the robbery. There were 2 people involved in the robbery. One person was committing the robbery and another person was holding the door. Okay. And they were wearing the mask. So face was not visible, but description, like, height, how do they sound, or like, body structure or something. So description was given, not of the face, actual face, but description of the person holding the door was given, and he was wearing the mask. And this description matched with Cohen. Cohen is the accused person here. And when he was arrested, he actually gave the statement to the police saying that, actually, I did not do this particular crime, but this particular offense of, robbing in the subway. But I recently spoke to my friends T and L. So their names are there in the case, not required for us. So his friends are there, T and L, who were like along with whom I was discussing about how an offense of robbery could be conducted in a subway. We were just talking. We were just casually talking about how offense should be convicted in a conducted in a subway. हमें mask पहनना चाहिए. We should have some armed thing with us. We should be armed with chaku or something, and it will be dark probably, so it is good that if we are wearing mask and all, they should not recognize us, nobody should recognize us. And whether to scare them with a gun or whether to scare them with some weapon, like that. Basically he had spoken about this with his friends T and L. And Okay. So then finally what happens? When Cohen versus Fisher, okay. The court says that the Crown can only prove the involvement of Cohen. In this, finally, what happened was the Crown can only prove the involvement of Cohen if Crown is able to prove that T and L is the person who committed the offense. Do you see the connection over there? Because Cohen has had only communication with T and L as per his statement. Now the Crown has to prove that T and L only committed. There were two people who committed the offense as per the facts. So if T and L committed the offense, then they can also bring Cohen into that particular case and make him a party as aiding or abetting. Okay, so that again, like they will see whether he only aided or whether he only abetted, whether only counseling was there. Okay, so here abetting or counseling was in question. So we will see counseling in the next class. So basically here what happened was question was to be decided is that the Cohen's role as a party to the offense on the basis of abetting or counseling. Lower court has acquitted Cohen as the evidence fell short of providing that Cohen was one of the principal offenders. पहले तो it was difficult for the court to prove that there was no evidence. Evidence was short, fell short. That means here basically evidence was description. Okay, because the masked man was there and description was like could be of anybody, right? Like lot of mismatch ho jata hai when the face is not clear and proper description of the face is not there or of the identity of the person is not there in the as per the witnesses, right? So evidence fell short on providing that Cohen was one of the principal offender. So first of all, we cannot place him on the spot. Okay, वहां पे दो लोग थे. There were two people, and Cohen is not one of them. On party liability. Now, next principal offender, he is not a principal offender. That was done. Next, on party liability, lower court held that Cohen could only be convicted as a party if Crown established that C's friend, that is Cohen's friend, T and L, had committed the robbery. But he concluded that the evidence also fell short in this regard. In this case, actually what happened, T and L also could not be placed on particular that subway. Okay, where in the event that particular robbery. So there was no evidence in order to enough to prove that T and L was the person, people who committed this robbery. Crown appealed. Obviously, Crown is not happy in the lower court decision, and Crown appealed to the Court of Appeal. And in Court of Appeal, what happens? They allowed Crown's appeal and set aside Cohen's acquittal. Now Cohen is again charged, right? So Cohen's case is continuing and his acquittal is set aside by the Court of Appeal. Now Cohen is also sad, and also our Crown Counsel is also is sad because he also wants to go against this particular decision because he wants to convict him, not just set aside the acquittal decision. Okay. So now Crown and the Cohen, okay, sorry, Cohen appealed Supreme Court of Canada against the decision of Court of Appeal. Mr. Cohen argued that trial judge made no error and his acquittal should stand. So earlier, whatever trial judge or lower court judge had told, ki this particular guy is free to go, like he is acquitted from the offense, and he says that obviously that is in his favor. So he argued that he made no error and this appeal and all is not required. Just stand that acquittal decision should be upheld. Now, Crown argued that the Court of Appeal was not allowed to limit a new trial to just one aspect of liability. Now, Crown said that Court of Appeal was not allowed to limit a new trial to just one aspect of liability. That means he should be charged from the beginning. Like here, new trial was actually given by the court. Okay, so new trial was given by the Court of Appeal, but the Crown is basically saying is that it is not sufficient. Instead, Crown said there should be a new trial on the charge of armed robbery as a whole. So what ultimately here actually what happened was like Crown's intention of again appealing and making like kind of annoying here was basically he says that we cannot rule out him being Cohen being a principal offender because already वहाँ पे evidence नहीं है. Evidence are fall short because he is not in that particular place. We cannot go as per his statement. There was no evidence that is proving his alibi also, okay, that he was somewhere else, that we cannot rule out. There is no enough evidence that we can rule out him being principal offender. So let us charge him as armed robbery as a whole. We cannot say that only one aspect ke liye, that is only for extension of liability as a counseling or only as abetting we will charge. No, let us charge him on the entire armed robbery as a whole, and let us continue this case in that manner. So final verdict of Supreme Court was that it has dismissed Mr. Cohen's appeal and allowed Crown's appeal. The new trial will be on the charge of armed robbery as a whole. Iska final decision we don't know, and in our syllabus they don't expect us to know also, but just they wanted us to see what and all happened, different stage trials. Court, what happened, they acquitted Cohen because there was no enough evidence to prove that he was the principal offender. And also for party liability also, the court said that Crown has to prove that T and L did it, then only C will come as a party because he had counseled them or spoken to them with respect to this. That also could not happen, so the case was dismissed. But Crown then appealed to Court of Appeal, and in Court of Appeal they set aside the Cohen's acquittal, and they ordered a new trial. And this new trial was not on entire thing. So Crown said that you are telling new trial for only one aspect of liability, but that is not sufficient. Let us charge him for a new trial on the charge of armed robbery as a whole. First, let us again check whether he is liable for the offense as a principal offender or not. Then only we will go and talk about being a party to the offense as a extended liability. When the evidence is short, it does not mean that we should go as per his statement and acquit him. We should make sure beyond reasonable doubt that that guy is has not done this particular crime. There were many other aspects also. For example, there was no enough alibi. The person could not prove his innocence on the rebuttal also. There will be a lot of other points, but we only have to see that, okay, when we are considering a person as a party, first we have to rule out that they are not the principal offender. So we have to charge them with the entire offense as a whole, and then we have to see that whether this particular person was a principal offender. If not, then we will go and talk about, okay, this is with respect to extension of criminal liability, aiding, abetting, counseling, or other parts. Clear? We will look into the practice question. Before that, any questions? Yeah.
So I'm just confused as to like in what some circumstances we can use this case law, because none of the parties were like considered as aiding or abetting on anything, right?
So it's kind of like, in my language, they say that Addagodir Deepadipina. I don't know how to translate that. It's like kind of vague, very vague. This decision is very vague because this is a new case. So they added this in our syllabus and they wanted us to get kind of confused. But we can use this case in a situation where it is quite difficult to pin them into, principal offender, or quite difficult to pin them as a party, somewhere in between, right? So even only if your situation in the fact is about in between, we can't prove them as the principal offender, we can't prove them as the party to the offense also. It is not clear. All other situations were clear, no? Previous cases all were clear. So here we could not pin down. So in that situation, use R versus Cohen and say that in that case also same thing happened. And finally, Supreme Court of Canada, what they did, they ordered a new trial for that particular offense as a whole. So same thing you write here also, this particular person, we cannot assume that he is innocent, or we cannot assume that he is the principal offender, or just aiding, abetting, or as a party to that offense. So new trial should be ordered, and full complete charge should be put on that particular person. So as per R versus Cohen.
Okay, makes sense.
Yeah. Now, Anubhav, can you read the case? Practice question. Rajat, yes.
Vidya, we were looking at that R versus Gauthier case, wherein we are seeing that there are different stages for defense of abandonment. For example, in a fact pattern, we if four of them are not, like for example, there are four elements of the defense, and out of which one is missing, or either two are missing, can we still go ahead with the defense with the abandonment, or it will not apply?
It will not apply. As per this case, it will not apply. You can write it down here. All elements should be applied.
Okay. Thanks. Thank you.
So, Anubhav, can you read the case? Practice question.
Hello. Yeah. Am I audible now?
Yes, you are.
Yes.
Give me a second. Okay. So Helly and her friends had visited a concert held at Stanley Park. It was a show to be performed by a popular musician. On the day of the event, Helly and her friends visited the venue and were awaited the arrival of the musician. Unfortunately, the musician arrived late by over 3 hours, which extended the duration of the concert to 3 a.m. After the concert had ended, Helly and her friends were struggling to find transport to find their way home, and were waiting for their Uber in a desolate parking lot. At this time, Houston, Edmund, and Mike arrived at the scene along with 5 other friends. While Houston and Edmund raped Helly, Mike and other 5 of their friends held Helly. Okay. Again, while Houston and Adam raped Helly, Mike and other 5 of their friends held Helly. Okay. Ultimately, based on the police complaint lodged, investigation commenced. During this, Helly recognized Houston, Edmund, and Mike. All of them denied the charge, and Mike specially raised the argument that he was never involved in the incident and had only witnessed the crime owing to being physically present at the crime scene. However, he stood there only for a few minutes before he exited the scene out of fear and anger. You are a lawyer at a leading criminal defense law firm, and Mike has approached you to draft a memorandum of arguments that could help him understand the feasibility of his case. He confesses to you that he knew nothing of the intended crime, and in fact, he had gone to the party with other friend Irwin, and he just so happened to run into Houston and Edmund. He says he met them by accident and had not planned to meet them at the concert. He also asked to undertake legal research to determine whether his mere presence at the scene would lead to attribution of liability.
Thank you. So this is the question. So to begin with, yesterday also I might have told, but again, whenever you are reading your exam question, so what happens in our exam is that there will be on the left side some background facts will be there. Most of the time in the criminal law exam, left side there will be background facts and additional background facts to each question if they need it. Then just before our answer ka jo box hota hai na, just before that they will give additional facts, and the direct question of that particular first question will be on top. So this is the question. Okay, this is the direct question, this is the background facts. So before reading the background facts, always in your exam, this is a tip for you. Always read the actual question. It could be two-liner or it could be one whole paragraph also. So read the actual question and understand who is the character, because we saw in the fact pattern there were more people, many people: Adam, Houston, Mike, five other people, Haley and her friend, we don't know her name, and we have so many characters, and everybody is doing one thing. But who we are only focusing on, who is the accused person here, or who is our client, or whom we are trying to pin this offense against, or what is our character, what is the person we are associated or like interested on in this particular question. So that we will understand by reading the final paragraph or from the exact question of that particular question number. So here you are a lawyer at a leading criminal defense law firm. That means you're a defense lawyer. Now, Mike has approached you to draft a memorandum of arguments. IRAC, whether they write a letter, write a memorandum, whatever they give, writing IRAC only. Okay. So that could help him understand. So we have to write a memorandum that could help him understand the feasibility of his case. So, do you think you have to write everything that is in his favor, or do you have to write something that could go against him also in the case? What you should do? If the question is asking something like this, that understand the feasibility of the case, or prepare a memorandum. Prepare a memorandum whenever they say, na, most of the time, 99.9% of the time, it is best to write both the sides. Okay, both the sides, whatever is supportive case laws are there, supportive answers are there. You have to write. You have to clearly say that this case law could go in favor of him, this case law could go in against him, the crown counsel would so and so, and as a defense counsel for Mike, they should take this particular stance. If they have asked about the defense, then you can talk about like what actual defense he can take. Otherwise, you can support your answers with the syllabus material. Now, he confesses to you. Additional fact is there. He confesses to you that he knew nothing about the intended crime. And in fact, he had gone to the party with another friend, Ivan. So Ivan is coming here. And he had gone to the party with Ivan. And he just so happened to run into Houston and Adam. He says he met them by accident and had not planned to meet them at the concert. Okay, that and all is fine. But he also asks you to undertake legal research to determine whether his mere presence at the scene would lead to attribution of liability. So you have to talk like to what extent the crown can actually prove that his mere presence would be enough or not. Okay, so we have to talk in favor of him also, against him also. So in a proper understanding, you should address that memorandum to Mike only, because you should write in a way where you are in the shoes of that defense lawyer, who that memorandum is read by Mike. Okay, so you would suggest Mike in the following manner, so and so, so and so. You should write in that. So in this paragraph, it says what you should write, how you should write, how much you should write, what things you should not consider. Okay, now here, this is what your client is telling you, that this is his version. But earlier, if you see, who gave this statement that Haley and her friend were struggling to find transport, and at this time they came, and this particular thing happened, and Mike and other five other friends held Haley. So Mike also did something, right? So facts suggest that Mike did something, and sometimes in your exam they might give that this is the Haley statement. If it is statement of someone else of the opposite party, you don't have to rely on them that 100%. But in our case, this case, we are not seeing that this statement was told by somebody, right? So as per the facts, this could be the fact that was derived by the court, that this actually happened, right? So if it is the statement of the complainant, so we can actually rebut that also. We can say that it is what they are saying, but we have proof. Of course, whatever we argue, we should support it with the evidences. But I'm just saying in that line also you can say. But here what happened, Here there is a proof that he was not merely present, was it? Was he just merely present there, or did he do something?
He held.
He was present at the time.
Yeah. So he was holding Haley and along with other 5 people. And later, what he did, he also stood there only for a few minutes and before he exited the scene out of fear and anger. Fear and anger. He went out of that particular scene. He exited the scene. So this particular question is designed for you to apply everything that we have learned today. So can I get some answers as to what and all case law that we have learned we can apply here and how we will like take about this? Priyank, would you like to try solving this question?
For the first part, the arguments in favor of Mike, that could help him. We can use R versus Gotha.
Mm-hmm.
That he on based on what he's saying that he ran away and all that.
Okay.
So one of the we can see what all conditions that he's satisfying,
Mm-hmm.
and
Okay, you're on the right line. Whether it applies or not, when you're applying, you will know. And in case what happens in the exam, sometimes we will think that, okay, this R versus Gautier I can use, and while doing it, I will understand, oh, Mike has actually done this thing. So he has not actually, in a timely manner, he had not communicated. He has done this after the fact. He did not call the police. Nothing he did. So then I understand that entire paragraph what I have written is going towards the opposite, like opposite party, right? So I can just change the statement that I have written slightly, and I can use the entire case on the other side. That also sometimes happens. Now, any other point for each of the facts? Now, how many parties are there? We are bothered about Mike, but what do you think is who are the principal offender? Do you think Mike is the principal offender or party to an offense? Let's start over there. Section 21.
party to the offense.
Party to the offense, yes. And was he aiding or abetting?
Aiding.
Aiding, correct. So first we should describe the situation, like the character, what part he is taking in the offense. Whether if we are talking about if we are representing Houston or Adam, they are actually raping Haley and they are the person who is committing the offense, right? And what else Section 21 says that they should have? All the parties should have
Common intention.
yes, yes, they should have common intention. So, does this Houston, Adam, Mike, and other 5 friends have common intention?
No.
Yeah.
So could be, could not be. That is where the line is there, gray line is there, where you can argue on both the sides. So on one side, you can say that Crown could say that by action of Mike itself is saying, right? So action of Mike itself is showing, proving that he had intention. He gave in. Like he saw Adam and Houston raping Haley, and he supported them. He aided them. That much is sufficient. Then later, you can also say that whatever this guy is talking about now, he said that he had no intention, he just ran to them. So premeditation of crime is not there, but premeditation is not required no for sexual offenses and all. It could be sudden provocation also, sudden plan also. Intention is required. Premeditation is not required for sexual offenses. For murder, it is required. First degree murder, it is required. Premeditation of the crime, but not for all the offenses. Okay. So here the offense is rape, and the principal offenders are Houston and Adam. So you have to apply section as per section 21, clause 1. Houston and Adam appears to be principal offender in the present fact scenario, and Mike and other 5 of their friends who held 5 of their friends uh, seems to be party to the offense as per part B of aiding the principal offenders. Here there are 2 principal offenders. Acha. Then we will be talking about complaint is lodged and investigation has commenced. During this, Haley recognized Houston, Adam, and Mike. Now, this part, see, this is what some statement that Haley is giving. Haley has recognized Houston, Adam, and Mike. Other people are also there, but she recognized these three people. Now, all of them denied the charge, and Mike specially raised the argument that he was never involved in the incident and had only witnessed the crime owing to the physically present on the crime scene. So he is mentioning that he is physically present there. He himself accepted that he is physically present there. And do we have a case for mere presence? So this case is there. On his side, you can say that mere presence is not sufficient, but you can continue saying that, however, in the instant case, he has not just had a mere presence, he has also acted in a manner which is aiding Houston and Adam. So that will go against him. That is likely to go against him. So you have to state the sentences in such manner that is making a flow of these arguments or flow of your memorandum. Okay. So for both the sides, it's not like in favor of Mike and in favor of the Crown Council, like separate, you don't have to do different paragraph. You can just continue like in a flow. One aspect you take. Talk about parties, talk about any rebuttal for that, talk about, Haley recognizing them, and talk about who is the, Mike's argument, talk about how that could be connected to one case and how it could be rebutted also. Not all the time you should support it with case law, wherein you get a case law where you are saying about mere presence, right? But about the opponent, Crown's Council side, you don't have to say that okay, there is this case which talks about here this guy is doing so and so, and mere presence ka case I am rebutting with this particular case law. Not required. Only one case, whatever is given. Now 5 case laws are there. No, as much as possible you just mention it. Here, Gautier case also, how Priyan said, actually Gautier case you can say because of this fact. For what fact you are applying what case, that you have to mark. So here, he stood only for a few minutes and he exited. So same defense as Gautier took, here Mike also can take. But same, ultimately in Gautier also what happened, after the fact she claimed this abandonment point and she also did fail to reach all those points. Here Mike also will be failed because he did not do any of the things over there. He had only the first point, that is the intention to abandon or withdraw, but that did not happen in a proper manner. So it will be not successful claim of that defense. Then so you have to finally undertake the research and you have to say that, okay, apply what you know. Here Coven not required, and here you can also apply Coven if you want. You can say that it is Crown could say argue that Mike is being recognized by Haley is sufficient, or it's a very good evidence that she has recognized him in the place, and he has done this is act, and that's a strong evidence. So something you can say, and here you have to say that we have to charge him with the entire rape charge as a whole. Then we have to see how much his involvement was there as a principal offender or as a party. Like that also you can connect and you can write. Okay, there is no restriction as to this much only you write or not. I'm not going to say that. But as much as possible, use the syllabus material. So this question, as when you read only you understood, no? So it is talking about party. There are more than one person and he is coming and asking you for feasibility of his case. That means you have to write both the sides, and he's also asking you to determine whether his mere presence at the scene would lead to attribution of liability. His mere presence, again, this is a keyword. Of course, here we are discussing immediately after this chapter. We know this is for this chapter, but in the exam, how would you recognize, right? So these are the key elements that that should help you in kind of otherwise directly the question will come. Okay, like yesterday's case we saw general offense case, no? So where the question will be like directly you have to see whether this particular person is liable of the offense or not. So one offender will be there, or directly about one person they're asking whether this person is liable of the offense or not. And of course, if there are more than one person, even in such scenario, you will write 21 clause 1 and 21 clause 2, common intention, every element of this particular answer. Isn't this sufficient? Like so much of material is there. This much is sufficient for the question that they are going to ask on that chapter. That much material is more than sufficient. That's why we are kind of, shortening the material from the elaborated textbooks and all, and giving only so much. I am sending one. Okay, I'm sending one photo of the key facts that I have just written. But if you don't understand my handwriting, just let me know. I just scribbled it about the facts of these 5 cases. So you can actually listen to the classes also. While listening to the classes also, whatever facts I've told, key points, you can keep marking them. And if you still like miss out on any of the facts and all, you can let me know. Earlier cases or something, you can let me know. I will give you the key points of those cases. All good?
Yeah.
Okay. So that's about it. So today's class, we have understood the concept of, this is very important topic, okay? Aiding and abetting, parties to the offense, very important topic. We can get a question about that offense question only. They might add this particular element over there. So be sure to write these cases in that question. So if the question is, so that's how the clubbing happens, and the question ka marks goes on increasing. If they are giving separately only this question also, then it would be going for like 20-25 marks. So now I want you to start writing the IRAC answer for this and submit it to me before tomorrow's class. We have discussed how to solve it. Now you have to just jot down it in writing. Unless and until you type the answers and send it to me, it is not going to help you like 100%. Only 50% what we are discussing is going to help. So unless and until you frame the sentences, and try yourself. Okay, this case, how can I apply? All those things. I might say, but actually when you're doing it, right? So yourself doing it will be helping you 100%. So you can practice on that, and I'll take a leave now. Thank you so much for joining, and I will share the word copy of the materials in some time.
Thank you.
Thank you.